Hi everyone and welcome to this edition of You and the Law. You and the Law basically sets out to discuss the issues of law in everyday living and to also discuss issues of law in the breaking news. Shortly after the delivery of the judgment in the case between Atiku Abubakar, Peter Obi, and the President of the Federal Republic of Nigeria, President Bola Ahmed Tinubu, an interview was granted to one of the leading lawyers in Nigeria, Robert Clark, senior advocate of Nigeria. He was granted interview by Channels Television the same day that the judgment was delivered. And in that interview, Chief Clark said clearly that the lawyers for the petitioners, that is the lawyers to Peter Obi and lawyers to Atiku Abubakar, were not circumspect in taking the brief from these gentlemen, that there were many things they did not do right. And it was for that reason that they lost at the Election Petition Tribunal and also lost at the Supreme Court. Today I'm discussing a few things that have arisen from this statement by our very highly respected senior advocate of Nigeria. For those that don't know Chief Robert Clark is a senior advocate of Nigeria, one of the oldest lawyers alive in Nigeria today. He cut his teeth in practice during his early years, his youthful years in practice. And he has his name in so many of the law reports as someone who had done high-profile cases, including election petition matters, up to the Supreme Court of Nigeria, became a senior advocate of Nigeria, had high net worth clientele, and he's a highly respected senior advocate of Nigeria. I must say this. But let's look at the statements that Chief Clark made. It asked the questions. It asked the question, what were the lawyers expected to do? I think this is the natural question that a lot of people will be asking. What were the lawyers for Peter Obi and Atiku Abubakar expected to do differently? Chief Clark has said that if he was in their position, he would not have taken the briefs when they came, that he would have analyzed the facts, would have analyzed the evidence at the disposal, and that he would have turned down the briefs of Peter Obi and also the brief of Atiku Abubakar. Well, Chief Clark has his own opinion, which is what he has made it clear for the whole world and to hear. And for me, that is his personal opinion. But when you look at law practice, sometimes it is a very tricky endeavor. Sometimes cases will come to you as the worst of cases. There is no hope in the case. And it is expected that as a professional, you should advise your clients as appropriate. At other times, cases will come without looking so bad. And so the lawyer, as a legal practitioner and professional, is expected to take the brief. He takes the brief, goes out there to do his best and to see what he can get out for his client. When you talk about election petition matters, election petitions are very tricky. They are extremely tricky. And in a country like Nigeria, where you have to prove a lot of things and where election materials, where election evidence is still largely in paper form, a whole lot of work is expected of the counsel for the petitioners. And that is why so many lawyers don't do election petition, because of the requirement of the law for you to prove your case as an election petitioner. A lot of our colleagues don't do election petition. And for those that venture into election petition, the hurdles to cross are just too many. I have done election petition more than one season. I've been counsel for the petitioners. I've also been counsel for the respondents. And I understand how difficult it is. I understand how tricky it is to do election petition. And therefore, the lawyers that took Peter Obi's brief and the lawyers that took Atiku Abubakar's brief may have taken the brief expecting, in all honesty, that they have something to present to the court. And in litigation, it will turn out one way or the other. This person will win, the other person is going to lose. They may not have known. They may also have known. And if you had known, the expected thing is for you to decline the brief and tell your clients as appropriate that, see, this case cannot be won. But there is another school of thought out there to say, who is the right person to say that the case cannot be won? Is it the lawyer or it is the court? A lot of people have said it is the court that should be allowed to determine whether a case is meritorious or not meritorious. But for me as a legal practitioner, what I think every legal practitioner should do is to carefully analyze the brief given to him by his client. Some cases are won and lost from chambers. So as you're preparing the brief, you should be able to know whether this brief is the kind of brief that has cogent and verifiable facts supported by law that you can win at the tribunal. Once you see that your case is such a weak case and there's no magic that you can do in the courtroom, I think it is advisable to let go of the brief in spite of how juicy the brief may be. This perhaps may be why Chief Robert Clark said what he said. He came out very clearly, and Robert Clark is not someone that minces words. He came out very clearly to say, see, the lawyers to Peter Obi, lawyers to Alhaji Atiku Abubakar did not do well in accepting the briefs, that they ought to have turned down the brief in view of the paucity of facts for them to use in proving the petitions that they took to the court. Like I said, this is Chief Robert Clark's opinion. I do not think that Chief Robert Clark is questioning their professional capability, but is basically sending a message out there to we lawyers that, see, once you see that the facts are such that you cannot win, once you see that the facts are not strong enough for you to present a serious case before the court, then it is advisable to let go of the brief. For me, I commend lawyers on both sides. Atiku Abubakar's lawyers, they did their best. Peter Obi's lawyers, they did their best. Tinubu's lawyers, they did their best. And at the end, it is the court that has decided the fate of the petitions that were filed. I do hope you have learned one or two things about the justice system in Nigeria, about the position of the lawyer when it comes to deciding on which case to take and which case to drop. It is my prayer that our justice system in Nigeria should have better speed. It took more than 7 months to decide those cases up to the Supreme Court. Let us have better speed where cases are decided also with the speed of light as quickly as possible, so that this legal system of Nigeria can be a well-placed and better adjudicated atmosphere for everybody to go to court and have judgment and go back home and continue with his businesses without much waste of time. Many thanks for watching. Follow this page, like this page, share this page, so that together we can sit as a community and continue to discuss the issues of law in the breaking news and general issues of law in society. I remain your friend and host, Ekemini.